Milord, the point arises, Milord, the background of this, let me tell you, Milord, there was a selection for appointment of teachers in 2016, which was set at naught a whole hog by this Honorable High Court, which has been upheld by the Supreme Court. Milord, that's not the issue. Now, the Honorable Supreme Court, Milord, gave them liberty to go for fresh recruitment. Now, in the name of going for fresh recruitment, they have enacted new rules. That rule is under challenge, its virus is under challenge. The virus of these rules was never challenged anywhere before. The court has recorded in division bench, the rules are not being challenged, therefore you are not interfering. Now kindly come to the middle of the rule. That is at page 32.
Yes.
This is of 29th of May 2025.
Why are you challenging it here in November?
No, the petitions are pending before this court for some time.
There are petitions pending, but you have not challenged it.
Yes. No, you mean Milord, several persons have not filed this petition challenging the virus of the rule. This is one of such petitions.
In November?
Yes. Anyway, but in November doesn't matter. That the challenging of virus does not depend on the particular time. They kindly see what is these rules. These rules are framed in by virtue of section 17 of the West Bengal School Service Commission Act 1997. I just take your lordship for prima facie satisfaction few of the provisions. The kindly comes to the provision of a selection of vacancy. This is very important.
Page
35, Rule 7.
All right. Information regarding vacancies.
Yes. The Commission of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement. Kindly, vacancy statement of assistant teachers. Therefore, the teachers who are already there, they really are not getting any vacancy for them. And with the approval of the state government, send the same to the board. The board shall, with approval of the state government, send the category wise so and so. This is the creation of vacancy for fresh selection. Now, while fresh selection is made, then the parties should be treated, Milord, at level, at par. All the applicants will have the same benefit of getting the getting entry into the service. Immediately, my lord will find that in these rules, they have created a class amongst the class. Kindly come to the schedule. This is the educational qualification, including professional qualifications for selection of assistant teachers. Therefore, the educational qualifications are at the entry point fixed. Now, kindly come to page 42, Schedule 2. Selection to the post of assistant teacher for class 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience. If this is a fresh recruitment for the fresh vacancies, you are inviting the existing teachers to participate, along with the fresh recruits, fresh graduates, fresh entrants. Oral interview and lecture demonstration determined by the Central Commission. Written examination, OMR based 60 marks is common to all. Academics, educational qualification common to all. Then kindly come B, prior teaching experience, 10 marks. Therefore, this 10 marks is additional benefit to a particular group who are also equally applying for entry into the same process. Whether this can be done. This would be apparently and patently in violation of Article 14. And then oral interview and lecture demonstration. Now, lecture demonstration of the persons who are allegedly worked, though illegally, and the appointments were set aside by the Honorable Supreme Court declaring void. Another question would come whether they can be given the benefit of that so-called experience. This prior teaching experience 10 marks would violate the Article 14. You are creating a class among class. But this is the values which I am challenging. Herein before, well, I must say, because I had the occasion to appear, petitions were moved by some group where the Honorable Division Bench says, since the rule is not under challenge, we are not interfering, giving certain reasons. Therefore, now the scope of this court, consider the values of the challenge, is that matter is still pending. And this is the petition that where I am challenging basically on this ground that you cannot at the entry point create a classification. By that you are trying to give advantage to the persons whose services were terminated. That's the intention. That you can come through back door. Giving 10 marks means all other new entrants will be out at the very threshold. Whether this can be done. This is the point.
Then, has the list of tainted and untainted candidates been published?
According to me, not. According to some, yes. The list which has been published, which I can demonstrate if you permits me from the Supreme Court judgment, is an incomplete list.
Alright.
Again, to protect a particular group. But I am not on that. I say that if the rule goes, then whether tainted, untainted, everything should go. At the threshold, everybody should be put on the same level without giving any additional advantage to X, Y, Z. That should be the compliance of Article 14 and 16 of the Constitution.
Show me the direction of the Honorable Supreme
Yes.
Court regarding this.
It's a copy আছে না না জজ সাহেবকে দিতে হবে
সিঙ্গেল বেঞ্চে প্যারা 12 এই জন্য ডিভিশন বেঞ্চ আর বলেনি, সিঙ্গেল বেঞ্চে প্যারা 12 বলা আছে। কেউ তো একটা করেছে রে ভাই, সবই তো একই ব্যাপার।
Give me the number. It can be put on the screen.
Yes,
The officer, the number.
দিয়ে দাও judgment delivered on সুপ্রিম কোর্ট হ্যাঁ 3rd April কেন হার্ড কপি আনো না বলি কথা শুনে এনেছি কোথায় কাজের সময় পাও না এনেছি এটা রিপোর্ট হয়েছে তো এটা
2025 INSC 34
বলো ওদের
2025 INSC 34 দিয়ে দাও 2025 INSC
ও করে বলি কাজের সময় ঠিক তৈরি থাকে না খালি মুখে মুখে তৈরি থাকে আইপ্যাড থেকে দেখো এটা রিপোর্ট হয়েছে তো
হ্যাঁ রিপোর্ট
তাহলে সেটা দিচ্ছ না কেন
2025 INSC 437
My lady, may I just make one point while my friend finds the papers, my lady? That the Supreme Court actually ordered the publication of the tainted and untainted lists.
Tainted
দাঁড়াও তর্ক করছো কেন
And to publish the list of the
দিয়েছো দিয়েছো ওখানে এসছে
Page 35, Rule 7, you mentioned something regarding the vacancy statement of assistant teachers,
Yes.
right? Your submission is that since the teachers are already in service, the post cannot be treated as vacant. But then the entire selection process stood nullified. Then where is the question of,
that's to nullify.
yes,
Therefore,
though
they are
the seats have to be treated as vacant only.
Yes, then how could you give
Yes,
additional 10 marks for teaching experience?
to that teacher.
This is a post for fresh recruitment, fresh graduates at the entry point. Then you come as a fresh graduate, but you cannot have the benefit of 10 marks for teaching experience. I'm not considering whether this was void or not. That means you are creating class amongst
that I've got.
that you cannot do. And
That
at the entry point, whether there are Supreme
I
Court
have followed
authorities.
it. I have followed it.
পেয়েছো দিয়েছো এসবকে Well, in the meantime, may I read out?
Yes, please read out.
এই জায়গাটা দেখো
The conclusion of Supreme Court judgment, paragraph 45.
এখানটা কমিশনকে একটু বলতে হবে
The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated, and they should be required to refund any salaries or payments received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. The next paragraph. For candidates not specifically found to be tainted, who are claiming to be untainted, the entire selection process has been rightly declared null and void due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled.
31st October.
However, the candidates who are already employed need not be asked to refund or restitute any payments made to them.
সেগুলো কি আছে আমাদের
Their services will be terminated. Further, no candidate can be appointed once their entire examination process results have been declared void. Therefore, the Supreme Court is very categorical that all the appointments having declared void, none of them could be appointed. There is no doubt in it.
All right.
And this violation of the rules was never challenged before. The division bench of this court said recorded that since rules are not challenged, we have.
Division benches order, please.
This is
No, no.
division benches order.
Division.
The division benches order I have handed over, my lord. Arunima Paul.
Provincial is ordered now.
Yes,
Your fifty though.
and
16 July 2025.
10th of July 2025.
so 16 July 2025.
In the matter of
16 July
Arunima Paul has been placed.
Arunima Pal?
16 July
It must be the same thing possibly.
Same thing.
16 July.
Same thing. 16th of July. Yes.
No, my lord, just before he,
Let him finish.
no, my lord, the writ petition, in the writ petition from which this appeal arose, my lord, there was a specific prayer, my lord, towards
challenging
by.
file.
And my lord, it was given up before the honorable single judge.
Whatever,
Well, let us-
yes, you
let us
will
not-
get a chance.
Let us
Yes.
not go by the judgment of the court.
Yes,
All the years.
Kindly come to page 24.
yes.
Division bench we order to
Yes.
এখানে continue
The
করতে হবে।
recruitment rules 2025 has not been challenged by any of the appellants.
Hmm.
In that background, the division bench order comes. But I know this specifically because I had the
Of appearance.
privilege of appearing before the division bench and
Yes.
Supreme Court as well.
পাঠিয়ে দে না
And then this order was appealed from Supreme Court, did not interfere.
All right,
But the point of why this challenge remains wide open.
all right,
And that's now I'm being canvassing before the lordship.
all right. This is all? Yes, commission. It is
Commission.
your rule that has been
State
challenged.
rule.
by rule my lord.
State rule. All right.
Yes my lord.
Yes, state.
My lord, I'll start by submitting that, my lord, the learned advocation has not been served, but I understand the bench wants to, my lord, look into the matter, my lord, so I'll address your lordship, my lord.
Please do.
My lord,
Start করেছো কিনা? সেটা দেখিয়ে দাও।
but the petitioner essentially is challenging the granting of the marks for the prior teaching experience. That is the long and short of the submission.
Yes.
Now, my lord, first your lordship kindly will take, my lord, the other batch of writ petition which was taken, if I may point out a singular paragraph of this honorable single judge's order, which was thereafter travelled before the honorable division bench.
Court's order I have handed over.
My lord, the single bench I'm handing over. The same, Arunima Pal. Yes. Single bench for now?
Just give 2 minutes. এই তোর iPad এ নে। আস্তে আস্তে কর, আস্তে আস্তে কর।
Now, my lord, yeah, my lord, we have the copy of Arunima Pal writ petition also, para 12. We have the copy of the writ petition also, which clearly says in the prayer that the various of the rules were under challenge.
But then the division bench is.
I'll say why this is coming. I'll say why this is coming. Can I take paragraph 12?
Yes.
learned senior advocate representing other groups of petitioners at the threshold has submitted that prayer B of the writ petition being WPA 13457 is not pressed, wherein declaration is sought for to the extent that the declaring the rules of 2025 and the recruitment notification dated 30th May 2025 ultra virus. So that prayer was given up. That is why the Honorable Single Judge did not decide the virus, and that is from where this submission is coming. Now kindly take the division bench's order. First, Malad, kindly take paragraph 28.
Yes.
In reply, Mr. Bikash Ranjan Bhattacharya, learned senior counsel, has submitted that the writ petitioners are not challenging the virus of the recruitment rules 2025, as their rights are untainted. Rights as untainted candidates are fully secured and has to be tested on the anvil of the judgment of the Honorable Division Bench in paragraph 363 Roman 11 read with paragraph 49 of the judgment of the Honorable Supreme Court. Now can I take the prayer of Arunima Pal? Give the prayer of Arunima Pal.
I'll give you.
But I am giving a soft call, kindly pardon me, Malad. This is the prayer of Arunima Pal,
All right, what is
where
the prayer?
the virus was under check. I'll read, Malad. Prayer B said that in Arunima Pal, a writ of and or in the nature of declaration declaring that the Kolkata Gazette dated 29th May 2025 issued by the office of the Principal Secretary of the Government of West Bengal and the notification dated 30th May 2025 issued by the Commission as being ultra virus to the Constitution of India. Now, Malad, this I believe is also filed from the same chamber that I find from the Advocate on Record's name, Malad. So, Malad, they are well aware that the virus was under challenge and it was given up by the before the Honorable Single Judge. Though the submission, no, it's about being aware whether there are averments or not. Now, Malad kindly takes the constitutionality, whether the state was empowered to introduce 10 marks prior teaching experience or not. Now, Malad kindly takes paragraph 34 of the judgment. Division Bench, page 22.
Yes.
The awarding of 10 marks is an weightage to be given on the basis of the experience, and it is only expected that in a selection process of this nature and kind, all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher. As rightly pointed out by the Learned Advocate General and the Learned Senior Counsel, appearing on behalf of the Commission, the appellants writ petitioners are not coming within the purview of the category in whose favor the benefits and concessions has been extended in paragraph 49 of the judgment of the Honorable Supreme Court. They are not candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for the service to in any educational institute. Then I will kindly skip over a few lines to the next page from the third line. If we accept the submission of Bikash Ranjan Bhattacharya, Learned Senior Advocate, then for the selection for the same subject, teachers, two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2025. The rules are more stringent and student-centric. The revision of the eligibility criteria, so and so, then the NCT, that NCT also allows it, is discussed. Then Malad kindly takes towards the bottom of that page, second last line. While the candidates with 45% marks in graduation may be eligible for the same subject, a candidate requires to apply under the recruitment rules of 2025 would have to fulfill a criteria of 50%, and both of them, if appointed, may be a teacher for the same subject teaching in different education institutes. This will result in discrimination and a compromise of the quality. The prior teaching experience is an important factor, as experienced teachers may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the appellant. The delay, but this is where, that is why the single judge's paragraph was important. They prayed for it but gave it up. The delay in the recruitment, fresh recruitment, is due to the pending litigations, and when the opportunity for employment is opened by advertisement, it is always open for the authority to decide the eligibility of the other criteria in the academic interest for the benefit of the student. We accept the submission on behalf of the state respondent that there is no specific direction in the order of the Honorable Supreme Court by which the state is obligated only to fill up the declared vacancies of the first SLST 2016. all the orders relating to the issue had directed the fresh recruitment to be carried so and so. Then my lord kindly skips over to the next paragraph. If the government, 35, if the government felt that the experience gained by the candidates is relevant, the court cannot take a different view in judicial review. Similarly, prescribing any age limit for the given post and also deciding to the extent to which any relaxation can be given to the said age limit are essentially so and so. But these are on the other points which has been discussed. Then I am skipping over a few lines. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called arbitrary or irrational. The eligibility criterion in the recruitment rules 2025 is in furtherance to the object of finding the best available talent. Therefore, the prior teaching experience has been considered by the division bench. It has been held that we are empowered to introduce it, and it is held that the court should not interfere in judicial review when the administration has thought it to be a fit exercise of their discretion, administrative policy. Therefore, at this point, I need not, my lord, elaborate whether the prayer was there or not, whether it was given up or not. It was prayed, it was given up. My lord, as far as the state is concerned, my lord, it is issue estoppel, my lord. This point has been decided. This order has travelled before the Supreme Court. We have placed in several matters, and all the points are discussed here together because there were many other challenges by several petitioners, my lord. All my learned seniors, my lord, assisted the Honorable Supreme Court. My lord, your lordships, my lord, even assuming that there was no challenge, it's a fresh challenge, fresh batch, who is, my lord, ultimately, what is the point? The point is, first of all, whether I had the power or not. Secondly, whether it's ultra-vires the constitutional scheme, whether it's creating arbitrariness is or not. But the power has been upheld by the division bench, then the Supreme Court, and the fact that it is not arbitrary within the campus of Article 14, that has also been discussed. But Supreme Court, I can copy.
Supreme.
I won't take soft copies.
No, my lord.
Yes.
Therefore, this point, your lordship will kindly not go into any further.